Speaker Karu Jayasuriya is expected to give a ruling on the ratification of the first optional protocol to the International Covenant on Civil and Political Rights or ICCPR in Sri Lanka. The government and opposition, after arguing on the question of ensuring people their rights through constitutional means, agreed to refer the matter to the Speaker.
The Singarasa case. The Supreme Court had in Singarasa case agreed that the government of Sri Lanka had set out the correct legal position, which stated its response to the HRC as follows. The Constitution of Sri Lanka and the prevailing legal regime do not provide for release or retrial of a convicted person after his conviction is confirmed by the highest appellate court, the Supreme Court of Sri Lanka. Therefore, the state does not have the legal authority to execute the decisions of the Human Rights Committee to release the convict or grant a retrial. The government of Sri Lanka cannot be expected to act in any manner which is contrary to the Constitution of Sri Lanka. In my view, it is nothing but an attempt by a judiciary to usurp the powers of both the legislature and the executive. The obiter dicta of the Supreme Court violates Article 3(4) and 27(2) of the Constitution. The Supreme Court does not have the power to violate the basic tenets of the Constitution, which unfortunately the Supreme Court has been doing in the last decade. Very, very unfortunate. Trying to override Parliament, lock up members of Parliament. That was the unfortunate period of Sri Lanka's political history. The judicial power of the people is not exercised by the Supreme Court, but by a Parliament through courts and directly by Parliament. And a decision of this nature can only become law if passed by Parliament by a two-thirds majority of the total membership of the House and moved by a referendum. The courts that have followed the obiter dicta have violated the Constitution. It's a judicial coup against Parliament and the sovereignty of the people. Instead of confining itself to the matters before it, the court has meandered into a totally irrelevant area and made pronouncements on the constitutional competence of the President to accede to the optional protocol. I believe something that should be left to the Speaker of the Parliament in this instance, and I had asked the Speaker to, after necessary consultation, to give his ruling on this matter.